Here's a very short and brutal story about how using a barrister can help you to get your money back if you have a judgment in your favour against someone that owes you money. So in this case, as is usual, we started out with a letter of claim from my client detailing to the defendant company exactly why it is we say they were in breach of contract and my client deserves his money back. At first, they ignored this letter, but on the follow-up, they said they had no idea who my client was. Fast forward a year later, we are in court with both the defendant and its two directors because we've added those both to the claim because the company denied all knowledge of my client. But at least one of the directors was responsible for dealing with my client in the name of the company because that is how my client entered the contract. After a number of contradictory documents were submitted to the court by the company and its two directors, the judge noted that one of the directors had failed to provide any evidence whatsoever. The defendant director assured the judge that he had emailed the court this evidence some weeks before. Of course, no one was going to take that on face value, so the judge said, okay, that's fine if you tell me that you've emailed this several weeks before. Why don't you go back into your email right now and forward me the email that you sent several weeks prior? After 10 minutes of sort of trying to pretend to look for this document, of course, the defendant director couldn't find it. We all suspect he hadn't sent it. And this trial happened to be by telephone during the pandemic. And at this point, the defendant director, probably realizing that he'd been caught out by not actually having sent this email to the judge, then hung up. At which point we received a judgment in full, joint and severally, against the company and its both directors. But of course, they didn't pay up within the 14 days that they're required to do so. However, at this point, with judgment in hand, my client now becomes a judgment creditor, and both the defendant and its two directors become judgment debtors. Of course, within the papers, we have details of the bank details into which my client made the payment. So we make an application for what's known as a third-party debt order. This is an order whereby a judgment creditor is owed money. The court can order the bank, in the name of any of the defendants, to freeze and then later pay over this money to the judgment creditor because the judgment creditor is owed the money. And by way of a short interlude, if you're wondering where all the noise comes from, it's from this black belt floof right here, whose channel is linked in the description, and she'd be very happy if you go there and subscribe afterwards. There are two stages to a third-party debt order, the first of which is the court will freeze the money and order the bank not to release that money pending a hearing, which is stage 2. We get to stage 2, which is the hearing in court, and the only argument that a defendant can really make is one of hardship. In other words, they need this money to survive on a daily basis. However, no one turned up to this hearing, but submitted some documents to say that there were loans outstanding to several other banks, which means that they really need this money that's in the account. But of course, that isn't a good enough argument or excuse to warrant a hardship order. But in providing us such documents, they also told us about yet another bank account in their name. So you've probably guessed it, yes, we make another third-party debt order against the other bank details, which we now have. Yet again, the court orders that bank to pay over the money to my client, the judgment creditor. Only this time something very strange happens. Now, bearing in mind this is a national bank, who I shall not name, but this time the bank just didn't pay over the money, even though it was ordered to do so by the court. Several weeks go by and I email the bank and say, my client still hasn't received the money, what's going on? I get a response from the bank to say a funds transfer has been made into the account details provided. Only that wasn't the case because no money was received. A few more weeks go by and I email the bank a few more times, only this time they go radio silent. They don't reply to me at all. At which point I take further instructions and we then write to the bank to say, if you don't pay over the money as you were ordered to do by the court, we will make an application to the court to hold the directors of the bank in contempt of court, potentially sending them to prison. Oddly enough, there's still no response from the bank, until, of course, we have a full draft of this application and we send it to the bank for the attention of the board of directors, and very shortly afterwards my client gets full payment of the monies together with the costs of drafting the application. So if you are in the position where you have a judgment against another party and they are simply refusing to pay you, come and see me and we might be able to do something about it. And in the meantime, thank you for watching.